Welcome to Let's Talk U.S. Immigration. Imagine you did everything right. You filled in the form carefully, gathered your documents, dressed smartly, arrived early, and answered every question honestly. And then at the window, the officer did not simply say yes. Maybe they slid a colored slip across the counter, maybe they handed your passport back with a letter, and your heart dropped. If that is you, or you are afraid it might be, this episode is for you. Today, we walk gently through what happens when a U.S. visitor visa interview does not go to plan, what a refusal really means, why it is so often not the end of the road, how to come back stronger for a second chance, and one genuinely inspiring true story to carry with you. Before we begin, everything you're about to hear is designed to inform and educate. Immigration law is complex, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
You know, we really need to acknowledge right at the top that the physical reality of this moment is just profoundly disorienting.
Oh, absolutely. It's a gut punch.
Right, exactly. Like, if you are standing outside an embassy right now, or if you remember the day you were, the sensory details probably just feel burned into your memory, you know?
Absolutely.
The heavy bulletproof glass, the echo of the waiting room, the static of that intercom speaker, it just feels incredibly isolating.
It does. And welcome to the deep dive, everyone. We know exactly why you are here today. You are either looking ahead, trying to gather every piece of knowledge you can to avoid a bad outcome.
Which is a smart move, really.
Right. Or, and this is perhaps the heavier burden, you are dealing with the aftermath of one right now. You walked away from that window and you were just trying to figure out what just happened to your plans, your life, your future.
Yeah, it's a terrifying spot to be in.
It is. So our mission for this deep dive is to completely dissect the true nature of a visa refusal, relying really heavily on the expansive legal research from our attorneys. We're going to take that paralyzing, terrible moment and transform it into an actionable roadmap for you.
I love that. And I think the most crucial thing to understand right out of the gate is that the reality of your situation is almost certainly not as catastrophic as your emotions are telling you it is right now.
I mean, it's easy to say, right? But when you're there...
Oh, for sure. When an officer hands your passport back, the rejection feels absolute. And it feels deeply personal.
Yeah, like they just rejected you as a human being.
Exactly. But immigration law operates on a very specific, highly mechanical set of rules. Those rules are codified in these massive volumes of law that they do not translate cleanly into everyday human emotions or even into standard English.
Right, and that translation gap is where the trauma happens, isn't it? I mean, The research from our legal team spends a lot of time on this specific phenomenon, the silence after the no.
It's a very real psychological thing.
They describe it so vividly in the materials. It's that, half second after the officer gives you the bad news, the world just goes quiet. Your ears start ringing.
Yeah, it's full-on shock.
Right. For you, the applicant, it feels like a plan you have been building for months, maybe years, is just shattering through a pane of glass.
Yeah.
It is a profoundly physical experience.
It's a textbook shock response, honestly. Your brain immediately catastrophizes because human beings are wired to seek closure. And, a rejection feels like the ultimate permanent closure.
You immediately think of the wedding you're going to miss, right? Or the business deal that's falling through.
The family members you won't see.
Yeah.
Exactly. The single thought that just drowns out everything else in that waiting room is, it is over.
The central thesis of our entire deep dive today, the absolute core message extracted from the legal research provided by attorney Chris Ingram, is 4 words: it is not over.
Yes, it is not over. And to understand why it's not over, we really have to look at the deeply deceptive language of immigration law.
Yeah, the wording is so harsh.
It is. Let's start with the heaviest word of all. Let's talk about the word refused.
Okay, because in plain English, right, if someone refuses you, that's a hard stop. It's a slammed door.
Right.
Like if I walk up to a restaurant and the host refuses me entry, I'm not getting dinner there tonight.
Right.
The word just implies a finality, a judgment, and a complete cessation of momentum.
That is the colloquial definition, yeah. But in visa terminology, under the statutes of U.S. immigration law, refused functions as a giant mandatory umbrella term.
An umbrella term.
Yeah. The law actually requires a consular officer to officially mark an application as refused if they cannot approve it right there on the spot during that specific interview.
So wait, the legal term refused is basically like a check engine light in your car.
Oh, that's a good way to put it.
Like, it could mean your engine's about to explode and the car is totaled, or it could literally just mean you forgot to tighten your gas cap after filling up.
Right, exactly.
The dashboard just shows the exact same scary glowing light for both scenarios. You just see red.
That is the perfect mechanical analogy. The light comes on, your stomach drops, and you just panic. But you don't actually know what the underlying problem is until you hook the car up to a diagnostic machine and look under the hood.
Right.
In the consular world, the word refused covers everything from I need one more piece of paper to we need to run a routine 60-day background check to, in very rare cases, you have a criminal history that legally bars you from entry.
But I have to push back on this system design. I really do. Why does the legal system use such absolute terrifying language if the reality on the ground is so nuanced?
That's a fair question.
Right. Why not have a status called pending or paused or under review? Why mandate the use of a word that causes applicants to have a mild heart attack on the sidewalk outside the consulate?
I hear you. It really comes down to the bureaucratic architecture of the Immigration and Nationality Act.
The INA.
Right, which was fundamentally codified way back in 1952. Bureaucracies prioritize legal definitions over emotional impact. The system is built on strict statutory binaries.
Meaning yes or no.
Exactly. Either a visa is issued today or it is not issued today. If it is not issued today, it must be statutorily categorized as to why.
So there's no gray area for the paperwork.
None. The law doesn't have a friendly checkbox for pending your teaching contract. It just has a legal statute that says, at this moment, the burden of proof for issuance is unmet. It is clinical. It is cold.
Wow. Okay, so for the applicant holding that piece of paper, the immediate task is translation.
Precisely.
You must separate the clinical legal term from your emotional reaction.
Yeah.
You have to react to the actual event and the specific paperwork handed to you, not just the terrifying word itself.
Exactly. And that brings us to the diagnostic framework we are going to use today. The research from our legal team lays out 3 distinct possible outcomes when you walk away from that bulletproof glass without a visa.
So these are the 3 diagnostic codes for the check engine light.
Exactly. The first outcome is the pause, which is technically called a 221G. The second outcome is the not yet, legally known as a 214B. And the third outcome is the deeper bar, which involves strict legal inadmissibility.
Okay, so almost everyone who walks away without a visa falls into one of these 3 distinct buckets.
Almost everyone, yes.
And identifying which bucket you are in is the single most important thing you can do, because the solution for each is entirely different.
Completely different.
So let's start by looking at the most hopeful scenario, the loose gas cap, the outcome known as the colored slip or the 221G pause.
Right. To illustrate how this feels and functions, the legal research provides a composite profile of an applicant based on real case patterns our team sees all the time. Let's call her Elena.
Okay, Elena.
So Elena is a secondary school teacher from Lisbon, Portugal. She is heading to her best friend's wedding in Boston. She has picked out her dress, she has purchased her flights, she has made all the hotel arrangements.
He's ready to go.
She has done everything right.
Right. She goes to her interview, and by all accounts, it's going great.
Yeah.
She answers the officer's questions warmly. She is completely honest. She feels confident.
It's a totally normal interview.
Yeah, there's no tension in the air. The interview is going perfectly fine till the officer suddenly stops typing, reaches into a drawer for a colored slip of paper, checks a box on it, and slides it under the glass along with her passport.
And in that moment, Elena's brain just short circuits.
Oh, completely.
She hears the officer say the word processing, but the blood is rushing in her ears. She walks out of the consulate clutching this colored slip, completely devastated.
She assumes she has ruined the trip.
Yeah, she is already dreading the phone call she has to make to her best friend to say, I'm so sorry, my visa was denied, I'm not going to make it to the wedding.
But the tragedy here is that she hasn't ruined anything. Her visa hasn't truly been denied in the way she thinks. She just didn't understand how to read the check engine light. That slip is governed by Section 221G of the Immigration and Nationality Act. And the definition of this section is going to be a massive relief for a lot of listeners.
It really is.
It is a pause. It is an administrative hold, not a true denial.
Right. A 221G means one of 2 distinct things is happening. Either the officer needs another document from you, a piece of information you didn't have with you, like a specific tax form or an employment letter.
Just a missing piece of paper.
Right. Or your case requires routine, behind-the-scenes administrative processing that simply couldn't be finished at the window during your brief 3-minute interview.
I want to highlight a statistic from the legal research here that should instantly lower the blood pressure of anyone holding one of these slips right now.
Yeah, this is huge.
According to the data patterns, around 85% of these 221G cases are eventually approved. 85%. That is an overwhelming majority.
It changes the entire emotional landscape of the event, doesn't it? When you realize you are sitting in an 85% approval bracket, you can see why this outcome is mostly good news, wearing a very frightening bureaucratic costume. The odds are overwhelmingly in your favor if you just take a breath and follow the instructions.
But I really want to talk about those instructions because the internet has created a massive mythology around this exact moment.
Oh, don't get me started on the forums.
Right. If you go on any immigration forum or social media thread, you will see thousands of applicants absolutely obsessing over the color of these slips.
Yes.
People are analyzing whether they got a blue slip, a white slip, a pink slip, a yellow slip. There's this pervasive belief that there is some universal global secret code.
It's wild.
Like, oh no, you got the yellow slip. That means they flagged you for fraud. Or pink means you're definitely getting approved next week.
It is entirely a myth, and it is a myth that causes immense unnecessary suffering.
So it's not real.
Let's state this definitively. There is no official worldwide color code for 221G slips managed by the State Department. A blue slip in the U.S. Embassy in London might mean something completely different than a blue slip in the U.S. Consulate in Mumbai,
Okay.
which might mean something else entirely in Bogota. The color of the paper is completely irrelevant to the legal status of your case.
Wait, I have to stop you there.
Yeah.
Because if the color of the slip genuinely doesn't mean anything universal, why on earth do consulates use different colors at all?
I know, it sounds crazy.
It just seems practically designed by a supervillain to spawn internet conspiracy theories and make applicants panic. Why not just print everything on standard white paper?
It comes down to the decentralized reality of running hundreds of distinct consular posts around the world, many of which operate in legacy buildings with their own quirky internal filing systems.
So it's just local organization.
It is purely an administrative convenience for the local staff inside that specific building. Imagine you are working in a consular mailroom, processing thousands of physical files a week.
Right, just a mountain of folders.
Having a stack of blue papers for needs a tax document and a stack of yellow papers for needs a security advisory opinion helps the local clerks sort things visually and quickly on their desks. It is an internal, localized filing system.
So it's basically the equivalent of using different colored highlighters in a college notebook.
That's a great comparison.
It means something to the person taking the notes, but it's meaningless to anyone outside that room.
Exactly. But the internet, in its infinite anxiety, tries to find global patterns where none exist. People compare their yellow slip in Paris to someone's yellow slip in Tokyo and draw completely false conclusions.
That's so dangerous.
It is. The golden rule here is completely ignore the color of the paper. The only thing that matters, the only thing that holds any legal weight or instruction are the specific words printed on the page.
Okay, so you're standing on the sidewalk, your heart is pounding, you tune out the color of the paper, and you actually read the text on the slip. What are the mechanical steps you need to take? What is the correct response?
If the slip explicitly asks for a document, your job is to provide exactly what is asked for. Nothing more, nothing less.
Just that one thing.
This is where people trip up. If the slip asks for your 2022 tax return, you do not send them your 2022 tax return, plus your 2023 return, plus photographs of your dog, plus a character reference letter from your local mayor.
But people do that.
They do it all the time. You send exactly the one document requested, completely and promptly, following the exact submission instructions on the slip.
That instinct to over-explain is so powerful, though. You feel like you need to prove your worth to them, so you try to drown them in paperwork they didn't ask for, just to show what a great candidate you are.
And doing so actually harms your case. Consular officers are drowning in paperwork. They process dozens, sometimes over 100 applicants a day.
Okay.
If they ask for one piece of paper to check a box and clear a hurdle, and you send them a 50-page dossier, you have just given them a massive administrative burden.
You're annoying them, basically.
You're slowing them down. They have to review what you sent, which takes time they don't have. Give them precisely the key to unlock the specific door they pointed to.
Now, what if the slip doesn't ask for a specific document? What if it just has a box checked that says your case requires administrative processing and gives no further instructions?
Then you are entering the waiting game. Administrative processing is a broad term that usually involves standard background checks or interagency clearances back in Washington, D.C. that take time to run through various databases.
How much time are we talking about?
It typically takes 60 to 90 days, though it can occasionally be faster or slower. This, by the way, is exactly why our attorneys constantly emphasize applying for your visa well in advance of your travel date.
Right, because if your flight is next week, this 60-day pause is going to completely disrupt your plans.
Exactly. But if you applied 6 months in advance, it is just a minor delay in the background of your life.
And what is the psychological trap here? What should the applicant absolutely not do during this waiting period?
You must resist every human urge to help the process.
I am beyond thrilled with my experience working with this team. From start to finish, they were highly professional, responsive, and thorough in every detail of my petition. They guided me step by step with clarity and confidence. Thanks to their incredible work, my EB-1A petition was approved, and I could not be more grateful. I would highly recommend this team to anyone pursuing EB-1, NIW, O1, or other immigration options.
Along.
Don't poke the bear.
Do not log back into the system and schedule a new appointment. Do not submit a brand new visa application hoping it goes to a faster officer. And, most importantly, do not repeatedly email or call the consulate every 3 days to ask for updates.
Which goes against every modern instinct we have.
Oh, I know.
We live in a world of Amazon tracking numbers and instant updates. If I want a package delivered faster, I pay for expedited shipping. If it's delayed, I refresh the app, I chat with customer service. Action feels like progress.
But in the consular context, your action is actively destructive. Every time you send an inquiry email, a consular staff member has to pull your physical or digital file, review the current status, draft a response telling you it's still processing, and then put your file back into the queue.
Oh man, so you're actually creating more work for them.
You are actively delaying your own approval and the approval of everyone else by eating up their administrative time. The only correct strategic action is to wait patiently.
Let's bring this back to Elena's story, because I think her journey perfectly illustrates the emotional whiplash of this process. Her initial reaction was entirely driven by raw emotion. She was terrified.
Completely understandable.
But her eventual success wasn't driven by emotion. It was driven by simply following the literal clinical instructions on the page.
Right. When Elena finally sat down at a cafe, stopped shaking, and actually read the text on her slip, she realized it just asked for one specific thing, a formalized letter from her school's administration confirming her teaching contract for the upcoming academic year.
That was it. The consulate just wanted to verify her employment stability, probably because she had recently changed schools or the database hadn't updated.
Yep, just a routine check.
She emailed her school principal, got the formalized letter on official letterhead, submitted it the very next day exactly as the slip instructed, and then she did the absolute hardest part. She waited.
She didn't panic.
She didn't panic. She didn't spam their inbox. She didn't buy a new dress. And just under 3 weeks later, she got a notification, and her passport came back with the U.S. visa securely pasted inside.
The event that felt like the absolute destruction of her plans, the moment that made her heart drop into her stomach, was literally just a single missing piece of paper. So if you are handed a slip, you must force yourself to take a breath. You are likely in that 85% bracket.
Elena's story is a massive relief, but it naturally leads us to the next, much more difficult question. What happens when the check engine light isn't just pointing to a missing piece of paper?
Right, the harder scenario.
What happens when the officer has all the paper they need, but they actually doubt you? That brings us to outcome 2, the 214B refusal and the massive invisible force called the burden of proof.
When you hear someone at a dinner party or on the news say they were refused a U.S. visitor visa, this is almost always the outcome they are talking about. It is the most common reason for a visa denial by a wide margin.
So this is the big one.
It is. To understand the mechanics of this, let's look at another composite profile from our legal team's research. Let's introduce Lucas.
Okay, Lucas. Let's talk about him. He's a bespoke furniture maker from a town in England. He has a small, thriving workshop. He owns his tools. He has a solid local reputation. And he is applying for a B1, B2 visa to travel to the U.S. for some specialized woodworking business meetings and a trade show.
Really standard business trip.
Right. These meetings are a big deal. They could really expand his business, maybe allow him to source new materials. So he goes to his interview at the embassy in London. He has real ties to his home. He is a legitimate business owner, but he's incredibly nervous.
And because he is nervous, his body language changes. His answers become clipped and short. They are flat.
He's not telling his story well.
Exactly.
Yeah.
When the officer asks him about his future plans for the workshop, he fumbles. He isn't sure how much detail to provide, so he gives vague, non-committal answers.
Like, ooh, just some meetings, stuff like that.
Right. The officer listens, looks at him, types a few notes into the system, and hands his passport back along with a standard letter citing a refusal under Section 214B of the INA.
So Lucas is left standing there, staring at this letter, realizing the biggest opportunity of his career just evaporated. He walks out, replaying the last 3 minutes in his head, agonizing over every clipped answer and every awkward pause.
It's agonizing.
And the psychological impact is profound. He feels like he's been accused of something terrible, like the officer saw right through him and decided he was a fraud.
To understand why Lucas failed and why he feels so terrible about it, we have to look at the specific legal architecture of Section 214B of the Immigration and Nationality Act.
A law itself.
Right. This statute states a very specific, aggressive legal presumption. The law presumes that every single visitor applying for a temporary non-immigrant visa secretly intends to stay in the United States permanently.
I really want to pause and make sure we underline this because it is the most counterintuitive part of the whole process. The law literally presumes you are secretly planning to immigrate.
Yes.
It assumes you are going to abandon your life and move to the U.S. forever.
Yes. That is the literal baseline setting of the U.S. immigration system. It is defensive. The burden of proof rests entirely, 100%, on the shoulders of the applicant to convince the officer otherwise.
So it's not on the officer to prove you're lying.
Exactly not. A 214B refusal is not the officer saying, I have proof you were going to stay. It is the officer saying, you failed to provide enough proof that you were going to leave. It means, I was not convinced you would come home.
So it's like gravity.
How do you mean?
Well, the 214B presumption of immigrant intent is a constant, invisible downward force. It's always pulling you toward a refusal.
Yeah.
And your ties to your home country, your job, your family, your property, that's the aerodynamic lift.
Oh, I love that.
You have to actively generate enough lift during that interview to overcome the gravity of the law, or you don't get off the ground.
That is a brilliant way to conceptualize it. You are guilty of immigrant intent until you prove your non-immigrant intent. The psychological blow of a 214B is severe precisely because people don't understand this gravity.
It feels like an attack.
It feels deeply personal. It feels like the officer looked you in the eye, evaluated your entire life's worth, and called you a liar.
But the research from our attorneys is very clear on this point. They aren't calling you a liar.
No, they are absolutely not. A 214B is not an accusation of fraud. It is not a legal finding of misrepresentation. It is not a ban from the United States. And there is no formal appeal process. You can't take a 214B refusal to an immigration judge and argue it.
So what is it?
Well, here's the most important liberating fact. It is not permanent. There is no fixed statutory waiting period before you can apply again.
Let's dig into the mechanics of that 3-minute interview, though.
Yeah.
Because I have to push back on the inherent fairness of this system. Lucas's ties were real. He really did have a workshop. He had a home. He had a livelihood in England. He wasn't lying.
He was a genuine visitor, yes.
Yeah, but the officer only gives him roughly 180 seconds to summarize his entire life's worth of roots. That doesn't seem like a failure of presentation on Lucas's part. That seems like a systemic design flaw. How is anyone supposed to prove a lifetime of ties in 3 minutes?
I mean, it is a harsh system, but it is driven by sheer volume. Consular officers worldwide process millions of non-immigrant visa applications every year.
Millions.
Millions! They do not have the luxury of spending an hour getting to know your life story. They rely on rapid triage. In consular training, they look at push factors and pull factors.
Okay, push and pull.
Right. Pull factors are things drawing you to the U.S. family members living there, better economic opportunities, a romantic partner. Push factors are things anchoring you to your home country, a thriving career, property ownership, dependent family members.
So in those 3 minutes, the officer is rapidly calculating the weight of the push factors versus the pull factors.
Exactly. And the failure for Lucas was a failure of presentation within that tight window. His push factors, his ties to England were real, but the story of those ties didn't land.
Because he was nervous.
Because he was nervous. He had the truth on his side, but he failed to effectively communicate it. The officer can't fly to England and physically inspect his workshop. They only have the evidence Lucas presents verbally and behaviorally in those 3 minutes.
Right.
Because his answers were thin, nervous, and vague, he failed to generate that aerodynamic lift. Gravity won.
Which means the truth Simply existing as a fact in the world isn't enough. You have to be able to communicate that truth effectively under extreme pressure.
Precisely. This is why our legal team emphasizes that a 214B refusal is best viewed not as a permanent no, but as a not yet and not like this.
Not yet and not like this. That's
Good. The officer is essentially saying, based on the specific evidence and testimony you provided today, the statute prevents me from approving this. Try again when you can show me a stronger, clearer picture.
If Lucas's problem was a failure of presentation, rather than a failure of underlying facts, how does he or how do you, the listener, actually fix it for the next round? Because you can't just walk back into the embassy the very next morning, knock on the glass and say, wait, I was nervous, let me try that again.
No, you absolutely cannot do that. And that brings us to the strategic core of today's deep dive. Our legal team's research outlines a highly specific 5-step strategic roadmap to overcome a 214B refusal and come back stronger.
Let's walk through these 5 steps methodically. Step 1, honest assessment.
This is often the hardest step psychologically because it requires you to put your ego aside. You have to truthfully identify your own weakness.
You have to look in the mirror.
You must look at your application objectively, trying to view it from the officer's side of the bulletproof glass. Were your ties to your home country genuinely thin on paper? Did your purpose for visiting the U.S. sound vague or suspiciously open-ended? Were you so paralyzed by nerves that you barely spoke, making you look evasive?
It's the ultimate reality check. You cannot fix a weakness you refuse to name. If you just blame the officer and say, they were mean, they were having a bad day, they just didn't like me, you learn nothing.
And you guarantee you will fail again.
Right. You have to ask yourself, what objective data did I give them to work with?
Exactly. Once you have identified the weakness, you move to step 2, real change. The single biggest, most expensive mistake applicants make after a 214B refusal is reapplying immediately with the exact same profile, just hoping they get a kinder officer the second time around.
It's treating the legal system like a slot machine, hoping for a different roll of the dice.
But the dice are loaded by your own history. The officer conducting your second interview will see the digital notes from your first refusal on their screen before you even walk up to the window.
They already know you failed yesterday.
Yes. They will be looking specifically for genuinely changed or significantly better presented circumstances. If you were refused because you were unemployed, you need to show you now have a stable job. If your ties were weak because you were fresh out of college, you need to show new professional roots or family responsibilities.
But let's be realistic here. What if you can't just magically buy a house, get married, or launch a new career in 2 weeks? What if your life is just your life?
Then the change you need is simply the passage of time. Let time pass so your circumstances can naturally mature. Many of the most successful reapplicants don't rush back. They wait a year, maybe 2 years, until their life organically strengthens, providing them with much more robust, undeniable ties to show the officer.
Okay, that brings us to step 3, better evidence.
When you do go back for your next interview, bring clearer, highly organized documentation that directly addresses the reason for your previous refusal.
So address the weak spot.
Exactly. If your job stability was the weak point last time, don't just bring a generic pay stub. Bring a detailed, signed letter from your employer outlining your specific role, your salary, how long you've been a valued member of the team, and most importantly, explicitly confirming that you are expected back at your desk on a specific date after your trip.
Oh, that makes sense.
If your finances looked weak, bring stronger, more comprehensive proof of your ability to fund the trip without needing to work illegally.
You have to make it undeniable. Which leads into step 4. Strict consistency. This one sounds incredibly crucial, especially considering what you just said about the officers seeing the notes from the first interview.
It is absolutely vital, and it's where many well-intentioned applicants accidentally destroy their own credibility. You must never contradict the core facts of your first interview. The State Department uses a massive interconnected system called the Consular Consolidated Database, or CCD.
The CCD.
Everything is tracked. If you try to invent new facts or alter your story to sound better, you will create a fatal contradiction.
For example, if you said you were going to Florida to visit Disney World last time, and this time you say you always planned to go to New York for a tech conference,
they're going to see that discrepancy immediately. They're going to think you're just making it up as you go along to find whatever excuse gets you in.
Right.
And suddenly, a simple 214B refusal, which is just a failure to prove, mutates into a Section 212 fraud investigation, which is a permanent legal bar. Your story must remain the same true story. It just needs to be supported by stronger evidence and told with greater clarity.
Which brings us to the final piece. Step 5, calm execution. You have to tell this true story warmly, plainly, and confidently. But the research from our attorneys gets into a really fascinating conversational technique here for handling what they call pointed or unflattering questions.
Yeah, this is a great strategy.
Because let's face it, consular officers are trained interrogators. They aren't always going to serve you softballs.
I had an excellent experience working with my caseworker Laura on my immigration case. She was consistently clear, organized, and communicative throughout the entire process. Laura always explained exactly what she needed from me to complete her drafts, which made everything feel straightforward and manageable. What stood out most was how willing she was to jump on a call whenever something needed clarification, and always with a supportive attitude. Her thoroughness and responsiveness allowed us to eliminate any confusion. I'm very grateful for her help and would highly recommend Laura and the law offices of Chris M. Ingram to anyone looking for a reliable and dedicated immigration services.
They might probe a weak spot in your history, and if you freeze up or get defensive, you look guilty. The research suggests mastering a technique called bridging.
Bridging is an advanced conversational craft. When asked a difficult or unflattering question, the most honest and effective response is to answer the question truthfully, but then immediately and gently steer the conversation back to the broader context and the facts that genuinely help your case.
I have to challenge this because, let's be real, isn't bridging just public relations speak for dodging the question? How do you pivot from a negative fact to a positive fact without sounding like a slick politician avoiding the issue?
I see why you'd think that.
If an officer asks about a 6-month gap in my employment, my instinct would be to either over-explain it defensively or try to change the subject. How does bridging prevent that?
That is a vital distinction we need to make clearly. A politician dodges the premise of the question entirely. If you ask a politician about a failing economy, they ignore it and talk about a foreign policy win. That is dodging, and a consular officer will spot it instantly and penalize you for it. Bridging, in an immigration context, means you answer the premise directly, acknowledging the negative fact, and then you immediately supply the missing context that neutralizes it.
Walk me through a concrete example. Show me how it works in practice.
Suppose the officer looks at your application, frowns, and says, "I see you were unemployed for a 2-year stretch recently." If you just say yes and fall silent, you leave a massive negative impression hanging in the air. Gravity is pulling you down.
So don't just say yes and stop.
Right. But if you dodge it and say, "But I have a lot of money in the bank," you look deceitful and evasive.
Right, you've ignored their concern. So how do you bridge it?
You might say, "Yes, I was unemployed for that specific period. However, during that time, I was focused on completing my master's degree, and since graduating, I have started a steady, full-time role in my field and put down clear professional roots here at home."
Ah, I see the mechanics of that. You aren't dodging the fact of unemployment. Yep. You're owning it. You're acknowledging the negative fact, but you're making sure they immediately have the full picture.
Exactly.
You're giving them the why, which is school, and the what happened next, a stable career. You've turned a liability into proof of long-term planning and stability.
Exactly. It ensures that in those precious 3 short minutes, the officer hears the reassuring reality of your life, rather than just zooming in on one worrying fragment. Every word you speak is true, but you are actively controlling the narrative context.
It's about taking the reins of your own story.
And this strategic assessment, figuring out how to present your complex truth clearly, identifying your weak spots, and learning how to build those bridges before you ever step foot in the embassy is exactly where consulting with the legal team at the law offices of Chris M. Ingram becomes incredibly valuable.
Because they can see the whole board.
They help you analyze your history, identify the structural weaknesses, and build the conversational bridges you need to succeed.
So we've explored how to fix a missing document with Elena's 221G, and we've explored how to fix a missing presentation with Lucas's 214B. But what happens if the problem isn't something you can fix with a new employment letter or a better conversational posture?
This is where it gets very serious.
What if the officer looks at your record and sees a ghost from your past? That transitions us into outcome 3, the deeper bar. and the absolute necessity of legal strategy.
This is the rarest outcome for your average tourist or business traveler, but it is by far the most serious. Sometimes a visa refusal points to a deeper statutory bar of inadmissibility under Section 212 of the INA.
Section 212.
We are talking about strict legal prohibitions, a criminal record involving crimes of moral turpitude, a past visa overstay where you remained in the U.S. illegally, a previous formal removal or deportation, or a finding that you committed fraud or were materially untruthful on a previous immigration form.
So if you are in this category, reapplying blindly, just booking another appointment, paying the fee, and hoping the officer is feeling generous, is that going to work?
Absolutely not. It is a complete waste of time and money.
Wow.
A 214B refusal is based on the officer's subjective discretion regarding your intent. These deeper bars under Section 212 are matters of strict objective law. If you have a disqualifying criminal record on file, the consular officer literally does not have the legal authority to grant you a visa, no matter how much they might like you personally or how excellent your presentation is. Their hands are tied by the statute.
So if you hit one of these depot bars, is the door just permanently slammed shut? Is it over?
Not necessarily, but it moves from being a simple administrative process into a complex, formal legal battle. It usually requires a process called a waiver of inadmissibility.
A waiver.
A waiver is essentially a formal legal petition asking the U.S. government to formally forgive the underlying issue, the crime, the overstay, and grant the visa anyway, based on specific mitigating factors.
This reminds me heavily of the deep dive we did previously on Esther, the ESTADA system for visa waivers, where we discussed how past records interact with automated systems and how waivers are sometimes required to bypass those blocks.
It's very similar, yeah.
The same principle of extreme honesty applies here.
Right, absolutely. The truth of the matter is nuanced. Some of these deeper bars can be overcome with the right legal help, a well-prepared waiver application, and the passage of time showing rehabilitation. Some bars are incredibly difficult to overcome and take years of legal wrangling, and a few specific violations create permanent, unfixable bars to entry.
For the listener who is sitting at home right now, knowing they have a shadow in their past, maybe a silly mistake from 10 years ago, a minor arrest in college, or a time they accidentally overstayed a previous visa by a few months, how do they even begin to figure out if that shadow is a permanent wall or just a high hurdle that requires a waiver?
The hard truth is they cannot figure it out on their own. Immigration law is too labyrinthine. The financial and emotional toll of just guessing in these scenarios is immense.
People must waste so much money.
We see people spend thousands of dollars on non-refundable application fees, taking time off work to travel to consulates, getting their hopes up, only to be denied again and again and again because they never addressed the underlying legal bar.
It's like trying to treat a broken bone with a Band-Aid because you don't have an X-ray machine.
That's exactly it. The smartest, most protective path you can take if you suspect a deeper bar is to get a proper, honest legal assessment from attorney Chris Ingram's team before you spend another dime on a doomed application.
Get the X-ray.
Right. They have the expertise to look at the specific statute you allegedly violated, analyze the timeline of events, review your criminal or immigration records, and tell you straight, yes, you have a bar, but we can apply for a waiver. Or, no, you need to wait 5 more years before a waiver is even possible. Or, in the worst cases, this is a permanent bar, and we need to look at entirely different long-term strategies.
Don't guess with your future. Get the X-ray. Now, the fear of these deeper bars, combined with the general confusion around the 214B intent requirements and the 221G slips, creates a massive vacuum of reliable information. And nature abhors a vacuum.
Yeah.
Into that space rushes a tidal wave of internet misinformation.
Oh, it really does.
Let's clear the air. We're going to aggressively tear down the most dangerous, persistent myths people believe about visa refusals.
These myths are incredibly stubborn, and they cause real, measurable harm because they lead applicants to make desperate, counterproductive decisions that damage their long-term immigration prospects.
Let's dismantle them one by one. Myth number 1, a 214B refusal brands you a liar and permanently flags you as a fraud in the system.
We've covered the mechanics of this, but it bears repeating because the psychological scar is so deep. The reality is, it just means not convinced, not yet. It is a snapshot of your failure to overcome gravity on that specific day. It is not a moral judgment.
Correct. Myth number 2, a 221G colored slip, is a polite way of giving you a soft denial.
Reality. It is a literal administrative pause, and as we learned, it's a pause that usually ends well, backed by that incredible 85% approval statistic if you just follow the instructions.
Myth number 3, reapplying the very next day or the next week improves your odds because it demonstrates to the consulate how serious and committed you are to your trip.
This is such a common, heartbreaking trap. People think, I was just nervous, I'll book an emergency appointment, go back tomorrow and explain it better. They'll respect my tenacity.
But it doesn't work that way.
The reality is it actively hurts your odds. The fundamental circumstances of your life haven't changed in 24 hours. You are just forcing a new officer to reject you again based on the exact same weak profile, which now builds a longer documented history of consecutive refusals on your record.
Which leads directly into myth number 4, perhaps the most financially damaging behavioral myth of all: consulate shopping.
Consulate shopping.
This is the pervasive idea that if you are refused at the U.S. Embassy in London, you can just hop on a train to Paris, apply at the U.S. Embassy there, and try your luck with a different set of officers, hoping they are easier or more lenient.
People actually believe this works.
Trying to consulate shop sounds exactly like a kid asking mom if they can have candy before dinner, getting told no, and immediately running into the garage to ask dad the exact same question, just hoping dad doesn't check his text messages from mom.
That is precisely what it is, and I can assure you the U.S. government checks its text messages.
They check the CCD.
As we discussed, the Consular Consolidated Database is global, interconnected, and updates in real time. The moment you step up to the window in Paris, the officer will scan your passport and immediately see the fresh refusal from London glaring on their screen. Furthermore, they will immediately wonder why you are applying as a third country national outside your home country, which instantly makes your ties to your actual home look even weaker and more suspicious. Your history follows you everywhere. The honest and only effective path is to systematically strengthen your case at your home consulate, not to try and outsmart the database somewhere else.
And finally, myth number 5, which is more psychological, but perhaps the most important one to dismantle. A refusal is a judgment of your worth, your success, or your integrity as a person.
It is deeply human to internalize rejection, but the reality is consular officers are making snap logistical judgments in 3 minutes about a specific set of paperwork on a specific Tuesday afternoon.
It's not about you as a person.
It has absolutely nothing to do with your integrity, your value to society, or your ultimate potential. Highly accomplished, wealthy, brilliant, globally recognized people get refused visas all the time simply because their specific presentation was structurally flawed on that specific day.
You know, when people are afraid, and when they lack clear mechanical information about how a system works, they look for loopholes like consulate shopping, or they fall into absolute despair, believing they are banned from America for life. The antidote to both the desperate loopholes and the paralyzing despair is cold, hard knowledge.
And if you ever need concrete proof that highly accomplished people get refused, and that a refusal does not define your future or your worth, the legal research provides an incredible piece of modern history.
This is without a doubt my favorite part of the research from our attorneys. Let me set the scene for you.
It's a great story.
It is the 1990s. The tech boom is just starting to rumble. A young software engineer from China applies for a U.S. visa. He's desperate to get to America to work in the burgeoning tech sector in Silicon Valley. He goes to his interview, he is refused.
So he regroups, analyzes his application, makes adjustments, and he applies again. And he is refused again.
And again, and again, and again. Over roughly 2 years, this young man went back to the embassy and was turned down 8 separate times.
8 consecutive refusals.
Think about the gravity of that. Think about the check engine light flashing in your face 8 times in a row.
The emotional resilience required to face that bulletproof glass, hand over your passport, and hear no 8 times is staggering. Most people would have completely abandoned the dream after the 2nd or 3rd attempt. Their family would have told them to give up.
But he didn't stop. On his 9th attempt, after 2 years of refining his approach, he was finally approved.
Why did the 9th time work? Because he learned, over those grueling attempts, how to convey his genuine purpose clearly to the officer. He learned how to generate aerodynamic lift.
He arrived in America in 1997. He spoke very little English and he had about $200 in his pocket.
That young man's name is Eric Yuan. He went on to found a company you have almost certainly used. He founded Zoom.
Zoom?
The video conferencing platform that, during a global crisis decades later, literally kept the entire world connected, allowed businesses to function, and let families see each other.
If he had stopped at attempt number 8, if he had let the system tell him his story was over, Zoom wouldn't exist. Now, we do have to contextualize this story carefully based on the research notes. These were specific employment-based visas in the 1990s.
Right, different circumstances.
It was a different era, with different geopolitical regulations and a slightly different INA framework than today's tourist visas. This is not a direct, literal blueprint for a modern B1, B2 tourist visa. You should absolutely not just blindly spam the embassy with 9 identical tourist applications.
Exactly. The lesson here is emphatically not apply blindly 9 times until they get tired of seeing you. The timeless human lesson we extract from Eric Yuan's story is that a refusal is not the end of the road unless you decide it is.
It's about resilience.
Persistence is key, but it must be informed persistence. It must be combined with genuinely strengthening your case and adapting your strategy. Without his persistence, he never would have made it. But without adapting his approach, that door would have stayed permanently shut.
But I have to ask you, obviously this guy is a legend, a billionaire tech founder whose persistence literally changed the world. But for our listener today, the regular person just trying to visit family in Chicago or go to a trade show in Las Vegas, at what point does inspiring persistence turn into just stubbornly wasting time, emotional energy, and non-refundable application fees?
It's a fine line.
How do you know if you're Eric Yuan on attempt 8 on the verge of a breakthrough, or if you're just banging your head against a brick wall for no reason?
That is the critical distinction, and it goes back to our strategic roadmap. You are banging your head against a brick wall if you are repeatedly applying without changing a single variable.
It's playing the slot machine again.
If you are just submitting the exact same profile, the exact same job, the exact same vague ties, hoping for a different result, you are wasting your money and damaging your record. However, you are on the Eric Yuan path if, between your attempts, your real-world circumstances are actively improving, or your ability to effectively present those circumstances is significantly maturing. If you are building a stronger business, gaining more career stability, purchasing property, and learning how to articulate your ties more clearly with the help of legal counsel, then persistence makes perfect sense. Your case is getting heavier, you are generating more lift.
So armed with the knowledge of what the different check engine lights mean, how to fix a presentation issue through bridging, how to navigate deeper legal bars, and the sheer inspiration of Eric Yuan's 9 attempts, what exactly should the listener do right now? What is the immediate action plan?
Let's summarize the calm, methodical sequence of actions based entirely on the research. Step 1. Identify your specific outcome. Are you dealing with a 221G slip, a 214B refusal, or a deeper Section 212 bar? Look at the paper in your hand. Diagnose the lights.
Step 2. If it is a 221G slip, read the instructions carefully, comply exactly with what they ask for, and wait patiently. Do not pester the consulate.
Step 3. If it is a 214B refusal for immigrant intent, do not rush back tomorrow. Identify your presentation weakness honestly. Let time or effort genuinely strengthen your real-world circumstances and prepare a much clearer, stronger case before you try again.
Step 4. If it is a deeper bar, a criminal record, a fraud finding, an overstay, do not guess.
Yeah.
You need a formal waiver of inadmissibility.
And step 5, which frankly applies to all of these scenarios if you feel overwhelmed, consult attorney Chris Ingram's team before spending more time and money. Getting an expert, objective read on your situation can save you from a massive amount of heartache and financial waste.
Let's revisit our composite profiles to offer some final closure. Think back to Elena, the teacher from Lisbon who panicked over her colored slip.
She got her happy ending.
She didn't let the panic dictate her actions. She got the employment letter, she submitted it, and she waited. She's now on that dance floor in Boston, celebrating her best friend's wedding just like she planned. That terrifying colored slip is just a funny bureaucratic story she tells at the reception.
And Lucas, the furniture maker who froze up, he is back in his workshop in England. He didn't get to those initial meetings, which stung. But he isn't defeated.
He learned from it.
He is gathering clear, undeniable documentary proof of his business roots. He is organizing his financial records. He is working with counsel. And he is practicing how to talk about his workshop confidently using bridging techniques. He is feeling calm and ready for his second application next year. Neither of their stories ended at the window.
And yours doesn't have to either. Consider this thought before we go. What if the U.S. visa system is designed this way, not just as a defensive wall to keep people out, but as a rigorous psychological filter? By putting the burden of proof so squarely on your shoulders, by enforcing this intense gravity of 214B, it forces you to become absolutely crystal clear about your own life, your own ties, and your own intentions. Maybe a refusal isn't just the system failing you. Maybe it's the system forcing you to truly understand value and articulate your own story before you're allowed to cross borders. It forces you to realize what anchors you to your home.
That is a profound way to look at the process. It transforms a bureaucratic rejection into a demand for intense self-reflection and clarity.
We really want to hear from you. What surprised you most about today's deep dive? Was it the fact that the terrifying word refused often just means they need one more tax document? Was it that massive 85% approval rate for 221G colored slips? Or was it the sheer grit of Eric Yuan being refused 8 times before building Zoom? Tell us in the comments. And if you haven't applied for your visa yet, please go listen to our companion deep dive, Part 1, the visa interview, which breaks down the mechanics of the interview itself so you can walk in ready to generate that lift.
Knowledge really is the best preparation you can have.
So let us leave you with the heart of it. The word refuse sounds final, but in the world of visitor visas, it very often is not. A slip is usually a pause that ends well. A 214B refusal is usually a not yet, not a never, an invitation to come back with your true story told more clearly and your circumstances genuinely stronger. And only rarely is it a deeper bar that needs real, honest help to understand. Whatever happened, respond to the real situation, not to your fear. Strengthen your case honestly, stay consistent and truthful, and never let a single hard day at a window convince you that your story is over. Remember the engineer who was refused 8 times and approved on the 9th and went on to help connect the world. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If you have been refused and want an honest, expert read on what to do next, visit breakthroughusa.com and reach out for a free consultation. And if you have not yet applied, listen to our companion episode on how to prepare and walk in ready. Thank you for listening, and we will see you next time.